Hello, welcome to this video on the civil courts. This is part of the AQA syllabus in the English legal system. The objectives of this video then are to explain the civil court structure, including the appeal courts, summarise the basic civil procedure, and evaluate the civil justice system. So the outline is going to be this. We're going to look at what civil law is, what the civil courts are and their powers, the jurisdiction of the civil courts, starting a court case, the track system, appeals and evaluation. So we will begin with civil law and what that is. So of course we need to remind ourselves that civil law is dispute between individuals. So it's where somebody's rights have been infringed in some way. Now this can be businesses as well, of course. You should note some examples where possible. Some examples I provide for you here is a television rental company claiming for money not paid on the TV renting agreement, so this could be contract law. A claim for the cost of repairing damage caused to a car because of another person's negligent driving, so this is a tort of negligence. A family claiming compensation for being put in substandard accommodation on a holiday package, again negligence. A landlord claiming for unpaid rent for an order that the tenant leaves the property, so this is property law. And a workman claiming for injuries he suffered because of faulty machinery, again negligence. So it's important as well as we go through this to understand how cases are written. So in civil law, an individual takes the action, so therefore the claimant's the first name on the list. So claimant versus defendant is the way things are written. So for example, if Mr. Smith sued Mr. Jones, then it would be Smith and Jones. Now of course those names are reversed on appeal, so it could be the appellant and the respondent. So the appellant is the person making the appeal, the respondent is the person responding to that appeal. Now in criminal law, the state takes the action through the CPS, the Crown Prosecution Service. So it's the Crown and the defendant. So for example, Regina and Rex. Regina being Queen, Rex being King, and Smith, for example there. So we looked at just broadly civil law. It's something we've done already in this course, but just a recap. Now again, you will be familiar with the civil courts. We have a county court. Okay, this is the lowest in the hierarchy, and it has most cases, civil cases, by volume. So for example, injured persons seeking compensation or businesses recovering money owed are examples of things which might be heard at the county court. Now they were created in 1846 as a cheaper way of dealing with small court actions. Now today there are over 250 of them, staffed by district and circuit judges. Now they can handle claims in tort law and contract up to the value of £100,000. Now this is subject to certain limits which we're going to discuss later on. Now the High Court is, as it might imagine, higher in the hierarchy, and it has 3 divisions of the High Court. Now they're more senior than the county courts, and it's based in London, but has 26 sitting towns and cities, or sits in 26 towns and cities throughout England and Wales. Now, the busiest division is the Queen's Bench division, and they deal with contract and torts. Now, when you sue somebody for negligence, for example, that is within the tort of negligence, but there are many different torts, and contract, as you might imagine, is a very busy part of the law. So what we have then, they also do some criminal appeals, as the Queen's Bench division of the High Court we looked at when we did criminal courts. Now the Chancery division then deals with financial issues, tax, property, wills and probate, land law and bankruptcy, for example, and maybe company law and other things of that nature too. Now there is also a family division, so they deal in things like divorce and family law and disputes for family under the Hague Convention, but in reality it only hears complex cases because most family cases are now in a separate family court. So we look now at the civil court. So we need to look at what the jurisdiction or the power of the civil court is. So that's what we're going to do now. We're going to look at the jurisdiction of the civil courts. So when we talk about jurisdiction or power, is to really focus at limitations. So at some point the powers of the county court stop and the High Court must take over, for example. So financial limitations are, with the claims for more than £50,000, this should be tried at the High Court, unless it's more suitable for trial in the county court, and that's because the High Court has unlimited jurisdiction. It can hear any amount of money, cases involving any amount of money. Now, it could also be a geographical limitation. Now, a claim can be started in any county court, but if it's a defended case, it's usually transferred to the county court nearest to the defendant's address. And of course, the defamation cases, so this is where one defames character, and you may sue because of this. So, for example, suing a newspaper for publishing a story which defames your character, and this must be started in the High Court. Now again, financial jurisdictions, just to reiterate, a type of case, so with personal injury claims of up to £50,000, they would normally start at the county court, and personal injury claims over £50,000 would normally start at the High Court Queen's Bench Division, but sometimes can be heard in the county court if the trial there would be more suitable. Now, if it's damage to property, claims of up to £50,000 would be heard at the county court, but damage to property for claims over £50,000 would normally be heard in the High Court. Now, a note here, this is subject to the track system. So all of this is a guide. When applying the law to a particular situation, you need to be aware that in fact the track system would be there's more guidance there in terms of what court we're going to and who's going to be hearing the case. So once we've decided then what's going to happen, we're going to start a case, we need to identify what happens. Now, this is subject to civil procedure rules, which mostly are beyond the scope of the AQA specification, but certainly some of the facets we're going to look at in the next slides. Okay, so most sensible people then will try to resolve disputes without going to court. Now, if we could put this into context, this could be you've had a car crash, or you have a dispute with your phone company, or you have a boundary dispute with your neighbour. Now, all of these things might be better resolved by discussing the problem with the person who you're having the dispute with. The courts themselves also try to discourage you from going to trial and actually encourage alternative dispute resolution, which we're going to cover later on in this course. Now, some of the reasons people might not want to go to court are because it's costly, it's very time consuming, it's adversarial, so it makes enemies of one another. Now, indeed, the disputes may be technical, so you might need to go to court to have it resolved, but in the main, you may wish to avoid going to court. But if it is unavoidable and you've gone through the ADR procedures, then you do need to follow up some protocols in order to put your case forward into court. Now, the first thing we need to think is we do have some pre-action protocols as outlined by the civil procedure rules. And so the claimant first needs to give notice to the other side that they intend to sue. Now, they must provide a list of evidence and witness statements. This is called a letter of claim, and the defendant has 3 months to investigate and then respond to this claim. Now, if you're issuing a claim, now the claimant will fill in an N1 form from the court. Now, this includes things like names of the parties and details including the value of the claim. The form is taken to court and the fee is paid according to the value of that particular claim. So, of course, it's higher for higher value cases and lower for low value cases. Now, you can also start claims online. So, we have here the claim must also be started online using the Civil Money Claim Service if it's under £10,000, or the Money Claim Online service if it's between £10,000 and £100,000. So this can be found online on the gov.uk website. Now, if you're defending a claim, if the other party is defending a claim, you'll file either an acknowledgement or service or a defence. And be assumed that he agrees with the claim, and the court will order the defender to pay up the full amount. So this is if you fail to file anything, then of course the court will assume you agree with it and will pay all of the money. Now, if you do deny the claim, then the court will allocate it to one of 3 tracks. Now this is an example of a claim form, or what the claim form looks like. So we have the claimant, the defendant, the brief details, and the value. Now of course you need the defendant's name and address should you have it, and a list of the amount claimed, the court fees, solicitor's costs, and so on. Now of course it does ask also about the Human Rights Act. Does it include any issues under the Human Rights Act? So for example, when we did statutory interpretation, we looked at the case of Gardner Mendoza. This would have potentially breached the Human Rights Act, so this claim would have been ticked. Now in terms of particulars of the claim then, so we need to make sure we've got as much detail as possible, and then we have a statement of truth in order to establish your honesty and to make sure you will tell the truth in court. So we mentioned once you've started a court case or wish to start a court case, it's in the judge's hands and they need to issue the case into a track. Now we're going to go through this in different ways, but fundamentally we have 3 tracks. We have a small claims track, a fast track, and a multi-track. Now the small claims track upper financial limit is £10,000. So if it's lower than £10,000 in any case other than personal injury, for which the upper financial limit is £1,000, then it will be heard in the county court with a district judge. Now for the fast track, this is the lower financial limit, everything between £10,000 and £25,000, apart from personal injury cases, whereas £1,000 or £50,000 is the lower and upper limit. Now again, this will be heard in the county court, but it will be heard with a more senior judge, a circuit judge. And then we have the multi-track. So this is more complex cases, over £25,000 or £50,000 for personal injury, and no upper financial limit, apart from if it's heard in the county court. So we discussed earlier that some high value cases may be fairly simple and might be more appropriate for the county court trial. Then this would be up to £50,000, but if it's over £50,000 then it goes to the High Court. But that is the normal method anyway for multi-track cases. And again, it is a circuit judge in the High Court. Now note, the High Court do also have High Court or puisne judges, but they would listen to appeals, and we're going to go into that a bit later on. So where a case is to be tried then is mainly dependent on the value of it. Now complexity might be a factor too, but primarily it is the money involved. So for small claims then, this is disputes up to £10,000, £1,000 for personal injuries in the county court. For fast track, straightforward disputes between £10,000 and £25,000 or £1 and £50 for personal injury. But then multi-track cases over £25,000 or lower value complex cases, so it could be complexity issue here. Now it could be the county or High Court, but mostly in the High Court, as we've described. £25,000 to £50,000 could be either in the High Court or county, but anything above 50 should really be going to the High Court. Now, once having a civil trial then, so a little note about the civil trial itself. Most civil trials are tried by a judge who sits in alone, and he decides both questions of law and fact. Now, a jury can be used in cases of libel, fraud, or malicious prosecution, but this is extremely rare. Now, each side calls evidence and presents legal arguments, and the witnesses can be cross-examined. Now the judge usually gives this decision immediately and awards damages, which is the amount of compensation awarded. In terms of costs, apart from the small claims track, the judge will order the loser to pay the costs of the winner. So this can include court fees, solicitor's fees, expert witness fees, and the cost of preparing for trial. Now this isn't the case, as I said, for small claims cases though. And that's because they're at a lower value, and usually lawyers are discouraged as well, certainly in the lower end of the value cases. Now, any time up to the end of the trial, either side can make an offer to settle. Now, if the other side refuses but goes on to win the case but doesn't match the settlement offer, now they'll be faced not only with their own costs but also the other side's too, plus interest. So it makes sense to try to avoid going into the courtroom and to actually try and settle outside the court. Okay, so just a brief explanation there of the track system. This will of course become apparent once you try to apply certain situations and see which track they fit into, and the guides will become apparent. So we're now going to look at appeals. So in terms of appeals, it depends where the case was first heard. So we might start then with a district judge in the small claims court, in the county court. Now in this particular case then, so a district judge, if you had an appeal, and the clue here is the blue is the first instance case, white is the first appeal, yellow is the second appeal. Now the district judge would go to a circuit judge within the same court. Now this would normally be on the point of law. Now with fast track, if heard by a district judge, then you would move on to a circuit judge on appeal, but again it would remain in the same court. But if you started off with a circuit judge, then you would go to a high court or puisne judge in the high court. Now again, going to high court, similarly to criminal law, it must be the point of law, a fact, or damages. Now with the multi-track cases, they're usually heard in the high court by a high court judge or a circuit judge. Now if it's heard by a circuit judge or high court judge, you would go to the court of appeal. Or there may be certain situations where you might leapfrog. Now leapfrog in this particular case just means to skip a court, so to go from the High Court directly to the Supreme Court. Now this is normally on a point of law and general public importance, statutory interpretation, or if precedent has not been followed, and this would go to the Supreme Court Justices. So that's the first appeal route for each of these. You should refer to this diagram to help understand the appeal routes. As mentioned though, there is a chance or an opportunity for a second appeal, and this second appeal would be from the small and fast claims track. Now you would go to the Court of Appeal if it would raise an important principle. Again, so this is a point of law of general public importance normally. So just to reiterate, some people would prefer to have this in a linear format, so this would be an option there. So in the small claims track, it's heard in the county court. Appeals from the district judge in the county court will go to a circuit judge in the county court. In the fast track, again usually heard the first instance in the county court, but appeals can be made from decisions made by a district judge to a circuit judge in the county court, or from a circuit judge in the county court to a high court judge in the high court. Now multi-track cases, these cases can be heard at first instance in either the county court or the high court, and the appeals normally go to the Court of Appeal, but you can leapfrog if it's a point of law of general public importance to the Supreme Court. Now usually only one appeal is allowed unless the case raises an issue of general public importance, so that is a high bar to pass. So in terms of appeals then, the rules regarding where appeals are heard are determined by the Access to Justice Act of 1999. Now this is created when Lord Wolfe reformed the civil justice system. So it produced a report and an act was created, the Access to Justice Act of 1999, and in this particular this set out the civil procedure rules and sped up the case, cases rather, created a track system, so it did speed up and improve the civil court process. Now it is the status of the judge that's a determining factor for appeals. So in theory, you go to the next judge in the hierarchy rather than always go to the next court in the hierarchy, as we might be used to in criminal law. So to appeal then, you need permission from either the original court or appeal court, and this is called leave to appeal. Now permission is only given if there's a real prospect of success or there is another compelling reason, for example public interest. Now the appellant must lodge an appellant's notice at the appeal court within 14 days of the original decision, and this states the grounds for appeal. And so this actually takes the form of a decision review of the decision made in the first trial. So it's not a rehearing of the trial itself, generally the appeal court will not hear oral evidence or any new evidence that was not heard originally. They will just look at the facts, look at the decision, and see would they have come to the same decision with the same information. Now the judges in the appeal may affirm or reverse the original decision or order a new trial. Now, a note on appeals from particular courts. From the county court, appeals can be made on alleged errors of law or fact. So from the court, the appeal is usually made to Civil Court of Appeal, Court of Appeals Civil Division. Now the court doesn't hear all the evidence again but considers the appeal, as we mentioned already. Now from the High Court, appeals can be made to the Court of Appeal using transcripts, and from there, if given leave to appeal, to the Supreme Court. However, it is possible to leapfrog the Court of Appeal and go straight to the Supreme Court on a point of law, if all parties, including the original the High Court judge, agrees. Now, from the civil jurisdiction of the Magistrate Court, appeals of family issues go to the Family Division of the High Court, and from there to the Court of Appeal, and then possibly to the Supreme Court. So now we've looked at appeals. We're now going to look at evaluation of the civil court system. Now, some advantages of this system then is the process is fair in that everybody is treated alike because the judge is impartial. The trial is conducted by a legal expert with the decision being made by a judge who is experienced and qualified lawyer. So of course this is in contrast to perhaps the magistrate's court, in which there's a lay person making the decision, or indeed in the Crown Court, in which lay people make the decision, but there are 12 of them. Now, enforcement of the court's decision is easy, as any decision made by a court can be enforced with the courts. So this could be, for example, if money isn't taken, there could be attachment of earnings orders and money taken directly from source to make sure any compensations or fines are paid. Now, there is an appeal process with specific appeal routes from decisions made in the courts, so if the claimant's not happy with the decision, it's usually possible to appeal against it. And it might be possible also to get legal aid, although legal aid itself, which is financial help for civil cases, has been considerably reduced in recent years. So there is still sometimes a case where it's available through the courts, but it's not usually available in other forms of dispute resolution, for example tribunals or ADR, so negotiation, mediation, conciliation, and so on. Some disadvantages still remain, even though the system has been reformed. So cost is a big example. So the cost of taking a case to court are often more than the amount claimed. Now in the High Court, the cost can be hundreds of thousands of pounds. Now for smaller claims, the costs, as I say, are often more than the amount claimed for. There is also a delay. So there are many preliminary stages to go through to add to the length of a case. Even after a case is set down for hearing at a court, there is still a long wait, usually about a year for larger claims, before the case is heard in court. This means that the total of all this can mean that some cases are not finished for years. In addition, it is a complicated process. Now, there may be many compulsory steps to be taken before a case is started in court. For example, for some types of case, the parties must use some pre-action protocols and give the other parties certain information. When the case is started in court, there are forms to be filled in and set procedures to follow. Now, these are all set out in the civil procedure rules. Now, all of this makes it complicated for an ordinary person to take a case without legal advice and help, which then of course adds to the cost element. There is also uncertainty, so there's no guarantee of winning a case. The person losing a case may have to pay the other side's costs. Now, this makes it difficult to know how much a case is going to cost in advance and can alter that decision making. You may pursue a claim or may not pursue a claim in relation to the uncertainty. So we dealt with evaluation now, and the final element we're going to look at by way of a bonus is reforms. Now, it is important to know that Lord Woolf, as we've mentioned earlier on, the Woolf Report led to the Access to Justice Act 1999, which did modernise the court system. You may argue it still needs modernising, and we're going to come to that in a moment. But what the reforms created was the three-track system. Now, the three-track system, the small claims track, the fast track, the multi-track, obviously helped certain cases be put in certain tracks and of course be dealt with in a more appropriate way. But ADR is still not used enough, so the Wolf reform did suggest the use of ADR, and indeed put forward procedures and blocks in order to use that before coming to court. Now, because it's not used enough, costs are still high. Now, courts are under-resourced as well. There are improvements in the delays, but still there's a 1-year wait for fast and multi-track cases. Now, it does give judges more responsibility for managing cases, which can speed up the process. It also led to more cooperation between lawyers, as mentioned before, with the civil procedure rules and processes. Information is needed to be given, so the claimant solicitor and the defendant solicitor, for example, would work together in some ways to come up with some kind of solution. Now, the Wolf reform also did simplify documents procedures and created a single set of rules, which each court used to have its own rules, and that, in a sense, was very confusing. But there is still some scope for future reforms. Now, there is now a mediation service available in the county court, which classifies as an alternative dispute resolution, or is, if you've studied the whole course and come back to this revision, understand mediation is an alternative dispute resolution method. It's a way of trying to resolve disputes without going to court. And indeed, an online court is in the process of being set up. Now, we can start claims online, but there is an argument or suggestion and pilot schemes that online courts are going to actually hear cases up to £25,000. Now, this essentially would mean the hearing is based on paper, and therefore, theoretically, should be quicker. Now, this is the process, so although an idea is not firmed up yet, so it won't be part of the exam as such.